But if there are no more questions, we'll listen to the opposition.
Okay.
Good morning, Madam Chairwoman, members of the committee. My name is Kevin Hayes, and I'm here on behalf of the Louisiana Landowners Association, and I've discussed this with Senator Amedee about our position to his local bill. I will suggest to you a couple of things. To begin with, Baton Rouge did have it for a specific project. That law is off the books. So let's be clear, Baton Rouge does not have this authority right now. I've researched it pretty thoroughly this morning, and I don't see anywhere where the city of Gonzales has quick take authority in this current statutes right now. Senator Cortez, you and I spoke about a bill you filed in 2009 for the town of Youngsville. It was specific to a certain project. We also talked about Representative Robideau's bill in Lafayette. It was specific to a certain project. And all through the statute, if you look at these type of bills, they're specific to a certain project that local government wants to or needs this draconian procedure of quick take. But let's go back to how we got here, if we will. In 2000, there was a lady named Miss Suzette Kilo in New Haven, Connecticut. And there were 140 homes that New Haven wanted to take through quick take. 135 ended up being willing sellers, and 5 of the homes decided they would fight the town trying to take their house. That went all the way to the Supreme Court, which in 2006 decided that, yeah, the town could take Miss Suzette Kilo's house. In response to that, and Senator Dorsey, you may remember, you were a co-author of the bill in 2006. The House passed a constitutional amendment that was adopted by the voters, setting up the expropriation process for the state of Louisiana. That's Article 1, Section 4. And so let's be clear of what that article talks about, and then we'll look at what Senate Bill 703 does. That talks about the right to property, that every person has the right to acquire, own, control, use, enjoy, protect, and dispose of private property. And that's what we're talking about in 703, private property. Section 4B2 talks about it has to be for a public purpose. Let's remember that. It has to be for a public purpose. And then 4B5, or actually 4, talks about that's a judicial question. The judge determines whether it's for a public purpose. Let's presume that the judge is going to hear evidence whether it's for a public purpose or not. And then the Constitution goes further to what the landowner is entitled to. He's entitled to the appraised value of the property. Let's remember appraised value. So let's look at public purpose, and let's remember appraised value. And then let's look at what Senate Bill 703 does. Remember, Ascension Parish right now has the right to expropriate property, just like any other municipality or parish does. But what they're doing is they're looking at doing this on these type of projects, road, sewage, or drainage projects. These are well planned out projects. These are not something where you flip a switch and you go do a project. Parish government presumably looks at those. But let's look at on page 2, line 5. The declaration is it's necessary or useful. It's not what the public purpose is. Necessary or useful. If you look at Webster's, I had a little time on my hands this morning, that's capable of being put to use. That's simply all that is. So if the property is capable of being put to use, it's useful and therefore can be taken. Paragraph B sets forth that the landowner on line 11, if he does not object, but there's no mechanism when he gets a letter from the parish on how he is supposed to object to his property. And if you look at line 12, that he will waive all of his defenses. Now, if you go to page 3 of the bill, we talk again about that it is necessary or useful, not what the public purpose of Article 1, Section 4B4 is. And then we heard them just talk about that they're going to get the money that the landowner deserves for the property. And Senator Colomb, you were right on point. A lot of these property owners are not sophisticated people when they come in and try to take a servitude. But it's not what the Constitution says that we just read about what amount the appraised value. It's the money estimated. Look at line 14. It's the money estimated. And who's doing the estimating? This isn't an appraisal. This is an estimation by local government of what someone's property is worth. So that flies in the face of the Constitution because it was clear what we did after the Kelo case here. Now we're going to have an ex parte order. For those that are not lawyers, that's something that can be done without the presence of the parties. So we're going to have an ex parte order on line 20. And we're going to declare that it's taken for a public purpose. So there's no evidence there. We're having a declaration that it's for a public purpose without the landowner being able to formally object and put before the judge, who the Constitution says is the one who's the trier of fact on this, that it's for a public purpose. And then the judge is going to direct that the amount of the estimate, which is on line 23, be deposited in the registry of the court. This is not the appraised value of the property. This is the estimate by local government. So we got an ex parte order where the judge is saying, yes, it's a public purpose, and here's the estimate of the money we're putting in the registry of the court, without the landowner, the owner of the property, ever putting forth any evidence that A, it's not for a public purpose, and this estimate is a very low number. I mean, we don't have any of that here in the bill. And now what are we going to do? We know that the beginning of the Constitution says we're going to protect the rights of property owners, but yet we're going to vest title in line 26 to the parish right away without any type of hearing or due process. So the parish owns the property now without the property owner ever having a chance to contest the public purpose or the estimate, if you will, of the property. And then we're going to notice the defendant after the fact. After this has all been done to him with this ex parte by the judge, Section 365 talks about notice of the defendant. It's on page 4, if you will. We're going to notify him of what? That his property, described in the petition, has been expropriated for public purposes. Remember, there's never been a determination by the judge that it's for a public purpose, that the Constitution requires there to be. And how much time are we going to give them for some of these unsophisticated property owners? Senator Clome, on line 15, we're going to give them 10 days. So they're going to have 10 days to come in, get a lawyer, and object. Or guess what happens to them at that point? They're going to lose their defenses in line 22. Waiver of all defenses. This is draconian at best. I understand that in the past there's been a need to use quick take. I understand that the policy of the state has been to allow the Department of Transportation to do this for certain roads. But allowing a parish government or a municipality to come in, and as we just went through it, I mean, they went through it kind of quickly, and I guess that's part of it with 703, the quick take. But if you really go through the bill and what it does to the property owner, and these are not going to be probably large landowners, but to the property owner, the unsophisticated person, he's now got an ex parte order, which is res judicata to some extent on the issue, that it's for a public purpose, and this estimate has been deposited in the registry of the court. And then he has to come back and overturn that burden that now faces him right then and there. You know, they had a bill last year for St. Mary Parish that was killed here at the legislature. My concern is that we start allowing this precedent to be set, and we start allowing these parishes to not have to follow the Constitution and the statutes that are in place for regular expropriation for these type of projects that are planned well in advance. Then quick take becomes the norm. We take people's property, and then we allow the property owner to come back in after the fact, after he gets notice that his property has been expropriated. That's just not the way to handle business. That's not the way to handle rights that are protected within the Constitution, and I would urge and request that you defer this bill. Thank you very much. I'll be happy to answer any questions.
That was my next question. Senator Cortez.
Thank you, Madam Chair. A couple things. You keep talking about the public purpose, but it says in the bill a number of times that it has to be expropriated for a public purpose. Revisit that for me with regards to how you're suggesting that it's not for a public purpose when it says in the bill clearly on page 4, line 7, clearly on page 4, line 14.
Senator Cortez, that's a good question. Now, let me tell you where I'm coming from. The public purpose is determined by the parish governing authority. They say it's a public purpose. The Constitution requires the judge to determine whether it's a public purpose or not. And we never get there.
So then
The ex parte order says it's a public purpose without any evidence being presented to the judge.
So you're saying that, and I know you quoted Article 1, Section 4 of the Constitution, so you're saying this is an unconstitutional bill?
Well, clearly, if we look at Section 4B4, whether the purpose is public and necessary shall be a judicial question. And it's not a judge determining that, which is what a judicial question is. It's a parish governing authority saying it's a public purpose. And this bill allows them to file that petition with that ex parte order, and the judge shall declare it's a public purpose without any evidence at all being presented by the landowner or the property owner, which under current law, that's how it works. The process right now is if the parish wants to expropriate property, the landowner says, or the property owner, no, this is not for a public purpose, then you go to the judge, and the judge determines whether it's a public purpose or not. In this case, the parish governing authority says it's a public purpose, and the judge shall sign the ex parte order saying it's for a public purpose. And then after the property is expropriated, the landowner or the property owner gets notice that their property has been expropriated for a public purpose when there's been no judicial determination as required by the Constitution.
And I know you're saying that, but again, being separate branches of government, I would think that the judge would say, I know it says right here in that statute that the legislature passed, it says shall, but I got a constitution right here that says that it's a judicial order, so I'm going to do what I want to do. And I'm not going to really care what the law says. I'm going to look at the Constitution and say what it says. So if you're saying it's unconstitutional, that's, to me, trumps anything we're doing here. But I'm going to move. Okay. I'm going to move on because I think we can say it's either unconstitutional or just a bad idea. But if it's unconstitutional,
I think both. Yes, sir.
Okay. Because it started out like it was a bad idea, and then it became unconstitutional. So I just want to be clear that if you think it's unconstitutional, I just want to make sure that's where you're at on it. Okay. If it were specific to a project or projects, would you then be okay with the bill?
I think there's, as we discussed, yes. I mean, generally,
let me set that in the context of a better question, because I think I may put you on the spot with that question. If the parish came to us with sort of a master plan, if you will, and said, we have projects 1, 2, and 3 that we'd like to do in the next 2 years, 4, 5, and 6 in the following years. And so in order not to make it a parish-wide deal, projects 1, 2, and 3, we believe are important right now, for whether it be drainage, sewer, roadway construction. And they came with projects 1, 2, and 3 in 3 different bills. Would you come to the table and say, I think that's a good idea?
Are you saying they're going to quick take these projects? I would say that's a bad idea because they can do it expropriation through the ordinary process right now, Senator. Right now.
I understand that, but if they came with those bills and said, if we need to use quick take authority on this project, if we need to. And the only reason I mean, I'm trying to figure out the reason to use quick take authority, in your opinion, is you're trying to expropriate, and again, I'm taking this from what Senator Amity said earlier, trying to do this public project, and there may be a landowner or two that is objecting to it for whatever reason, and it's holding up the project. They have the right to do it, but instead of doing it this year, it may be 3, 4, 5 years from now. That's the essence of the bill, right?
That's correct.
Okay. So if it was the parish's intent to build a particular road, let's use road as an example, to build a road that was needed for the public purpose, and it was established by the council, say a unanimous vote. We're having fun with this analogy or scenario. A unanimous vote, and then they were directed to go do it but couldn't do it for a number of years, because they didn't